And what's your reaction to the sentence of 32 months?
There's no pleasure to be taken. 9 people are dead and a man's in prison, and over a dozen are wounded. So our reaction is that the justice system has gone through the process. We advocated hard, so did the defense. The judge made the decision, and but in the end, it's a tragedy in all respects and all around.
Is that a fair assessment, though, when his crime was not directly related to the shooting?
A fair assessment being that it's a tragedy all around? Yes, it is a fair assessment.
When we asked about the sentence, you immediately brought up the shooting.
Because, as I advocated in court, there's no way to separate the two. The two crimes that Mr. Kollie pled guilty to and for which he received the sentence today are inextricably intertwined with the events of August 4, as we advocated in court and as I'm saying today.
You don't believe he was a scapegoat in this instance?
No, I wouldn't use those words.
I mean, do we believe that if, Mr. Kollie acted differently, that it might have changed what happened on August 4th, or maybe, could it have any impact on that, on the shooting, the mass shooting?
We argued in our papers that impaired judgment is a large part of this case. It's one of the reasons why Congress prohibited drug users from having guns. And it doesn't take a huge leap to come to that conclusion. It's a common sense notion. People on drugs just shouldn't have guns. And Congress has said so, and said so with force by making the penalty for that crime up to 10 years in prison. So this is serious business. And when someone like Mr. Kollie has not just guns, but 4 guns, 2 of them being semi-automatic weapons, and one of them he helps assemble and get parts for the ultimate shooter, it's a domino in the series of dominoes leading into that August 4th shooting. So like any child who plays with dominoes know, you take some of those dominoes out and those dominoes fall, but the others don't. So is there a possibility? Anything's possible, of course.
In court you said that he may not have known what the shooter's plan was, but you couldn't say for sure that he shouldn't have known.
The evidence that the government ascertained during its investigation was not enough to show or to prove beyond a reasonable doubt to 12 members of a jury that he knew. Had it been, as I argued in papers, the charges would have been much different, perhaps either federally or even across the street in the district attorney's office, right? That's actual knowledge, right? But that's a different question of whether Mr. Kollie should have known, right, of Mr. Betts' plan. That question isn't ripe for a criminal prosecution. We're here in criminal court.
Can you give some example of evidence that he maybe should have picked up on this? I mean, was there significant evidence that Mr. Kollie was exposed to things that pointed towards what Mr. Betts did? Well, I know you said that you can't prove reasonably.
No, I mean now we're talking about a hypothetical case that wasn't brought. That was not this case. So I'd be hard pressed to speculate about factors of what he should have known.
What about his attorney? I mean, his attorney says that it should have been a mitigating factor that he cooperated so fully. And I mean, do you feel like the sentencing? Do you feel like his cooperation was already reflected in the reduction in the sentence? And what do you actually feel about it?
Let's just be clear. As I said in court, there's a difference between cooperation with law enforcement that leads to an investigation, perhaps, or charges against another for which someone then receives some sort of benefit. Right? That's not what happened here. He was cooperative with investigators when they were tracking down leads from the shooting, and that's very different than cooperation. Now, he was cooperative, right, and it seems like he got some benefit from that. He also accepted responsibility for which he also received a benefit under the sentencing guidelines.
We had some family members of the victims in the courtroom today. What do you hope that this finding in this case, the sentencing, does for them and for the others who were not here?
I think this applies to all the victims from that shooting, and I don't know if it's really whether this case or this sentencing is it, but I hope everybody finds peace. I hope that they can find a way to stop hurting, because I think right now they're still hurting.
You talk about the seriousness of this case. Should we anticipate to see more of these cases coming through your office now?
I don't think you'll see a uptick or downtick. As I also indicated in my papers, this office has brought these type of charges when fair, just, and appropriate, and I cited a number of examples of instances where this office has brought charges for, let's say, lying on a form and being a drug user in possession of a firearm. You'll see examples of that as well in cases that we and other U.S. Attorney's offices have filed. So it's not something that just never gets filed. There is a steady stream of them, and I would anticipate that we will continue to bring such charges when it's fair, just, and appropriate.
You got it?
Good.
Thank you, Paul. Thank you.